Today's legislation hearing show so many of us just how much times have changed. In 1993, RFRA passed both the House and the Senate with near unanimous bipartisan support. Then Representative Chuck Schumer was the lead sponsor in the House of Representatives, while Senator Edward Kennedy carried the bill in the Senate, where it received 97 votes. When President Clinton enthusiastically signed the bill into law, he noted how a, quote, broad coalition of Americans came together to make this bill a reality. Mr. Chairman, the 1990s weren't exactly a time of bipartisan unity. Yet, despite the intense political debates that took place, Republicans and Democrats came together to protect the religious freedom of all Americans. Religious liberty remains the bedrock of the American experiment, and Republicans remain firmly in favor of RFRA protections. Unfortunately, my friends on the other side of the aisle are fighting tooth and nail to eliminate religious liberty and advance the radical pro-abortion agenda by rolling back common sense conscience protections. My first question is a simple yes or no question. And Ms. Laser, I'll start with you. Do you think doctors or nurses should be forced to participate in abortions? Yes or no?
That's a more complicated one.
That's what I thought you would say. Ms. Wiltshire, do you think that doctors or nurses should be forced to participate in abortions?
As my colleague said, it's complicated.
Reverend Hawkins, do you think doctors or nurses should be forced to participate in abortions?
Should be forced again?
Should be forced to participate in abortions.
I don't think they should be forced.
Okay, Mr. Sharp, do you think doctors or nurses should be forced to participate in abortions?
No.
Thank you. Mr. Sharp, as you testified, Congress intended RFRA to serve as a balancing test, not picking winners or losers, but respecting the faith practices of all Americans. RFRA does not allow the federal government to burden religious practice unless it can prove that it has a really good reason or a compelling interest, and that the government's purpose is accomplished with as little a burden as possible on the individual. This balancing test has been instrumental in numerous U.S. Supreme Court decisions. Take, for example, the Zubik versus Burwell decision, where a unanimous court ordered that the government stop penalizing the Little Sisters of the Poor, an order of Catholic nuns for choosing health care that meets their needs. Or the 9-0 U.S. Supreme Court decision Holt versus Hobbs case, which permitted a Muslim inmate to have a half-inch beard. Mr. Sharp, do you think the Supreme Court was wrong in those decisions to uphold religious liberty?
No, I think they did exactly what RFRA was designed to do: protect religious liberty, provide people of faith an opportunity to get relief.
Okay, and as a follow-up to that, Mr. Sharp, who is best to define what the tenets of the Catholic faith are? The government or the Little Sisters of the Poor?
The Little Sisters of the Poor.
Go ahead and expand on that.
We should all be worried when the government has the authority to determine what a particular faith believes or whether certain beliefs are consistent with the faith. There's been numerous Supreme Court decisions on that exact issue. We want religious individuals who have a duty to the omnipotent being that they serve to alone be responsible for determining what they are compelled to do, what they feel that their faith defines them. And what the government's role is to provide broad protections for that belief so that those individuals are not forced to do something that they believe violates those deeply held beliefs.
Okay, thank you. With the time I have remaining, I'll yield it to Dr. Fox.